The question is that the bill be now read a second time. Mr. Lewis Ng.
So this bill updates our laws for the protection of state land with modern provisions. State lands belong to all Singaporeans and we must protect it from being damaged or unfairly used for private purposes. I thus support this much needed review of the law, but I have three clarifications. My first clarification relates to the defense against an offense of unauthorized use of state land. Under Section 7, someone accused of unauthorized use of state land must prove that they did not know and could not have reasonably expected to know that the land was state land. In some cases, it's fairly obvious that the land is state land, such as setting up makeshift structures or farms in forest areas. But it is less clear in cases involving the boundaries of private property and state land. The average homeowner would not know whether their fence crosses into state land. Homeowners would likely rely on the expertise of their contractors to ensure compliance. Workmen would also rely on the instructions of their managers. Would reliance on the due diligence of third parties be enough to make up the defense in Section 7? In addition to one map app example in the explanatory statement, can SPS give guidance when someone would not be reasonably expected to know if the land was state land? My second clarification relates to the purpose for objecting to an encroachment notice. Section 12(3)(a)(2) states that the encroachment notice must state a timeline to comply with the notice and to raise objections. However, there is no requirement or guidance on the minimum time that must be provided. Given that encroachment might involve a person's home and that rectification might be complex or expensive, there must be sufficient time to seek advice on whether to raise objections to the encroachment notice. Can SPS confirm that reasonable time will be given to raise objection proportionate to the facts of each case? Also, where objections are raised, the Act is silent on any procedure for the authority to consider the objection and notify the recipient of the results or reasons for rejecting the objection. Instead, it only states that on receiving an objection, the officer may make a criminal complaint to a magistrate. This approach appears to skip the necessary steps to resolve the objection in a clear and transparent manner. Given that land issues can be sensitive due to costs or attachment form, we should have a clear process to reach a smooth resolution. Can SPS clarify if, prior to a criminal complaint, the authority will notify the results of the objection and give time to comply with the encroachment notice? My final clarification relates to the forfeiture of abandoned land. Can SPS clarify how the authority will determine that the land is abandoned? Given the scarcity of land in Singapore, it would be economically efficient to ensure that abandoned land is reclaimed by the state and applied to the benefit of all Singaporeans. Can SPS share some estimates of the amount of land that might be abandoned? Will the authority be taking active steps to identify abandoned land and use these processes to recover land as state land and then re-inject it into the market? So notwithstanding these clarifications, I stand in support of the bill.